Chapter 2, Sharia's Grip, Legal and Cultural Infiltration. Sharia law creeps into Western societies through education, legal accommodations, intimidation, and strategic institutions like mosques and Islamic centers. This chapter examines how these pathways allow a religious legal system to infiltrate and transform Western democratic attitudes and institutions from within. Section 1. How Sharia norms are undermining Western law. As Western institutions concede to religious demands in the name of diversity and inclusion, Islamic legal norms gradually displace secular standards, especially in areas such as civil law, education, finance, and freedom of expression. Sharia advances by exploiting widespread ignorance, misplaced optimism, and strategic messaging, while its beneficiaries actively suppress scrutiny. It is often said that Islam teaches Muslims to obey the laws of the land in which they live. This sounds reassuring, but the doctrinal position is more complex. According to Sharia, obedience is due only to those who rule by what Allah has revealed. Quran 5:44-47. Any legal system based on man-made law is considered kufr, disbelief, and Muslims are forbidden to follow it once Islamic authority is established. The full context of these claims is rarely explained and in many cases may not even be known to those repeating them. The issue of intentional omission and doctrinal deception will be addressed in more detail later in this book. Quran 4:59. O you who have believed, obey Allah and obey the messenger and those in authority among you. And if you disagree over anything, refer it to Allah and the messenger, unquote. According to classical tafsir such as Ibn Kathir, those in authority refers only to Muslim rulers. Quote, we gave our pledge to Allah's messenger to hear and obey our leaders, Muhammad said, except when you witness clear kufr about them, which you have clear proof from Allah. Even if a slave was appointed over you and he rules you with Allah's book, then listen to him and obey him in obedience to Allah, which they command you, not what constitutes disobedience of Allah, for there is no obedience to anyone in disobedience to Allah. Muhammad said, whoever obeys me obeys Allah, and whoever disobeys me disobeys Allah. Whoever obeys my commander obeys me, and whoever disobeys my commander disobeys me. And those of you who are in authority in the obedience to Allah, which they command you, not what constitutes disobedience of Allah, for there is no obedience to anyone in disobedience to Allah. Therefore, whatever the book and Sunnah decide and testify to the truth of, then it is the plain truth. What is beyond truth, save falsehood. Obedience is conditional, valid only if the ruler enforces Sharia. A secular state that does not rule by the book of Allah cannot be obeyed in matters where its laws conflict with Sharia, which is comprehensive and binding, except where temporary suspension serves the interests of Islam. This principle is reinforced elsewhere. Quran 5:51. O you who believe, do not take the Jews and the Christians as allies. Quran 45:18. Then we put you, O Muhammad, on an ordained way, Sharia, concerning the matter of religion. So follow it and do not follow the inclinations of those who do not know. As with al-wala wal-bara, loyalty and disavowal, Muslims are to show loyalty to fellow Muslims and disavow disbelievers, even if they live in non-Muslim lands. The assumption that Sharia can be confined to personal belief or that it bends to host country law is not supported by Islam's foundational texts. In earlier decades, this doctrinal incompatibility was recognized. Yet today, it is precisely this misunderstanding that prevents resistance. Incompatibility is no longer acting as a barrier. Western institutions increasingly accommodate Islamic norms and at times prosecute on their behalf. This shift is accelerating the transformation of non-Islamic societies into Islamic ones. Major online platforms reinforce this confusion. A simple search for Islam on a popular shopping site yields dozens of titles, nearly all offering positive portrayals that, whether by intent or ignorance, omit Islam's harsher doctrinal elements. Books that challenge the dominant narrative are frequently suppressed or delisted as controversial. Yet this belief system demands adherence to a religious legal code fundamentally incompatible with Western civil law. Western leaders may assume that Islamic doctrine has changed or that it can be modernized or reinterpreted to suit Western norms. But Sharia remains intact, and it is being implemented not by conquest, but by consent. The collapse of equal justice. In 2024, a German court sentenced a 20-year-old woman to a weekend in jail, not for committing a crime, but for speaking out against one. She posted hateful remarks online about 9 men who robbed and gang raped a 15-year-old girl. Quote, her assailants had begun inviting other men to rape her via their chat groups, gleefully sharing the news that there was an isolated teenage girl in a dark park with no potential witnesses, unquote. 8 of the 9 men received no jail time at all, even though their sperm from all 9 was recovered. 20 lawyers were assembled for their defense. None of the perpetrators were of German heritage. Yet over 140 German citizens were placed under investigation, not for aiding the criminals, but for criticizing them. Such outcomes are no longer isolated. A two-tier legal system is emerging, where Islamic sensibilities are being treated as a protected category, even when they contradict long-established principles of civil law. Critics are policed, offenders are shielded, and the underlying doctrine remains unexamined. In Islamic law, a woman's testimony is worth half that of a man's. If she is raped and cannot produce 4 male witnesses, she is presumed guilty. If she remains silent but becomes pregnant, she may be charged with unlawful sexual intercourse. Quran 4:15. And those of your women who commit illegal sexual intercourse, take the evidence of 4 witnesses from amongst you against them. And if they testify, confine them to houses until death comes to them or Allah ordains for them some other way. This doctrine continues to be enforced in Islamic states today and is increasingly echoed or accommodated in non-Islamic countries through policies that favor Sharia compliance over equality under civil law. Across the UK and Canada, polygamous marriages, long forbidden under Western law, are quietly taking place. In Victoria, BC, an Islamic center openly advertises Islamic or legal marriage on its website and provides a fillable online form to apply. In the UK, couples are offered unregistered Islamic marriages with no legal standing. The state is aware of these unions but does not pursue enforcement. Under Sharia, these marriages are valid and often include multiple wives. When Western institutions recognize Islamic law as simply another religious practice rather than as a competing form of governance, they legitimize a body of law that contradicts core civil rights. This grants a supremacist doctrine equal standing with secular law, despite the fact that Islam itself recognizes no such equality. This results in one-way accommodation. The West tolerates Sharia, but Sharia does not reciprocate. The quiet rise of Sharia norms. As Islamic legal norms gain ground in Western policy and practice, universal human rights are being sidelined, not by formal repeal, but through quiet erosion. The Cairo Declaration of Human Rights has become the unspoken standard, both influential and uncontested at the United Nations. Within that legal order, women, kafirs, and dissenters are not equal because the doctrine forbids it. This inequality reveals itself not only in modesty codes and speech restrictions, but in family law, where the increasing prevalence of polygamy, child marriage, honor killings, and female genital mutilation, coupled with an absence of prosecution, signals strategic non-enforcement. The result is harm, not only to individual victims, but to society as a whole. Those tasked with upholding the law are often restrained, not by moral considerations, but by political ones. The UK Home Office acknowledges the existence of unregistered marriages, many of which are polygamous and leave women without the protection of civil law. These women are often denied access to financial remedies upon divorce and have no automatic inheritance rights. The EU reports further confirm that many Muslim women are pressured to accept religious arbitration in matters of divorce, inheritance, and business, in direct violation of equal protection principles. These practices are not incidental. They reflect adherence to a parallel legal system, one that in some cases is enabled by the state itself. The UK Home Office defines polygamy as when a man has multiple spouses and outlines conditions on its website under which such arrangements may be recognized and an allowance paid. In certain circumstances, UK welfare benefits may even be paid, effectively legitimizing polygamy, despite its incompatibility with British civil law. In Canada, constitutional challenges have already been raised against Section 293 of the Criminal Code, the law prohibiting polygamy on grounds of religious freedom. If religious freedom justifies the accommodation of Sharia-based polygamy, then it can also be used to defend slavery, stoning, the amputation of limbs for theft, and the killing of apostates and kafirs. All are permitted under Islamic religious law, Sharia. Quran 4:3. And if you fear that you will not deal justly with orphan girls, then marry those that please you of other women, 2 or 3 or 4. But if you fear that you will not be just, then marry only one of those that your right hand possesses. That's a slave. What is being undermined is not only the civil code, but the principle of equality before the law. This is not the first time a society has had to grapple with core religious practices that clash with civil law. In the 19th century, the United States refused to admit Utah as a state until the Church of Jesus Christ of Latter-day Saints officially renounced polygamy. It wasn't just a theological disagreement, it was a legal one. Congress deemed polygamy, along with slavery, to be incompatible with American values and law. In 1856, the Republican Party's national platform declared it, quote, the duty of Congress to prohibit in the territories those twin relics of barbarism, polygamy and slavery. It was only after LDS President Wilford Woodruff issued the 1890 manifesto ending the practice that Utah was allowed to join the Union. Silencing critique. Western governments possess the legal means to enforce marriage registration, prosecute violations, and ensure equality under the law. The practices such as polygamy are instead being defended as a religious right, reflects not a legal obligation, but a failure to set limits on what qualifies for protection in the first place. Ironically, at the same time that Sharia practices are being defended on religious grounds, access to Islamic source texts detailing their full legal scope and incompatibility with Western values has never been easier. Global literacy is rising, and high-quality translations of the Quran, Hadith, Tafsir, and Sharia manuals are now readily available in multiple languages. Digital communication enables the rapid, unfiltered sharing of doctrinal content. This growing access threatens the narrative control long maintained through a combination of blasphemy laws in the Middle East and ignorance in the West. The Western principle of free speech may also explain why the Organization of Islamic Cooperation began publishing annual Islamophobia reports in 2008 and successfully lobbied the United Nations to establish an international day to combat Islamophobia in 2022. The continued oppression of Afghan women and the reluctance of many media outlets to report on it suggests that while such measures do little to protect Muslims living under Sharia, they are highly effective in silencing those who speak out against it. In the UK, several political parties and public institutions have adopted a definition of Islamophobia proposed by the All-Party Parliamentary Group on British Muslims. It states, quote, Islamophobia is rooted in racism and is a type of racism that targets expressions of Muslimness or perceived Muslimness, unquote. Although this definition has not yet been formally adopted by the UK government, it is already affecting institutional policies and public discourse. But Islam is not a race or a people. It is a belief system, and Sharia is its legal expression. If criticism of Sharia is branded as racism, the doctrine becomes immune from scrutiny. The result is that a system that mandates religious and gender apartheid is protected under anti-racism policies. This linguistic perversion is not a mistake. Its institutional adoption will be examined further on in this book. If the OIC's concern were truly for people, the term would be Muslimophobia, not Islamophobia. That distinction matters. Protecting people permits critique of the doctrine. Protecting the doctrine forbids it. Muhammad said, "O women, give alms. As I have seen that the majority of the dwellers of hellfire were you women, I have not seen anyone more deficient in intelligence than you," he said. Is not the evidence of two women equal to the witness of one man? This is the deficiency in their intelligence. Bukhari 304. Around the world, a climate of censure and self-imposed silence is allowing Sharia to take root, along with the same legal inequality and systemic repression that have always marked Islamic rule. The pattern is not new, only the setting has changed.